Van Loggerenberg is one of the 5 arrested in an operation by South African police and US Homeland officials, where personal computers, flash drives, and tablets containing child pornographic content were seized. It emerged that his recent crime contravened the conditions of his suspended sentence from the 10th of March 2015, which was scheduled to expire in a few days. The applicant's criminal history, which includes 5 counts of statutory sexual assault, was raised and extensively debated by the state and the defense. Both parties offered motivation on whether or not his past should be taken into consideration for his bail application.
It is of utmost importance that this court give cognizance to the fact that with reference to his previous conviction, there was indeed consensus. Your Worship, it is of utmost importance that the word statutory be taken into account when considering the previous conviction. Had the applicant, for example, been standing on rape or compelled rape, the situation would find itself in a very difficult place. The offence before which the applicant now stands, although it can be classified as a sexual offence against children, there is no physical interaction with a child or with children. It is important that we come to terms with the fact that the applicant is standing on a charge of contravening Section 24, subsection capital B of the Films and Publications Act.
The release of accused on bail will expose children that we have in his vicinity to danger, in that he does not seem, according to the evidence before court, the allegations in the present case and the previous conviction, he doesn't seem to have changed, to have had change of heart. I submit, therefore, that taking the totality of the case, effects of the case into account, and including the past history of the accused, taking that into account, it is clear that there is a likelihood, at least the Act does not say certainty, but likelihood is sufficient that he will infringe on the right of the children.
After deliberation on both arguments, the magistrate handed down her judgment.
The court is of the view, given the history in this case, that there is the likelihood that the applicant, if he were released on bail, would endanger the safety of the public, or that he will commit a Schedule 1 offence. The court is of the view that the applicant has failed to discharge the onus that he bears, and that it is not in the interest of justice that his application be granted. His application is accordingly refused.
Women and Men Against Child Abuse welcome the magistrate's justification and final decision.
We're very pleased that she has used some very strong arguments to deny him bail, because our communities are safer for that. Like we said earlier today, there are children who have succumbed to the lack of intricacies, the lack of detail, attention to detail when judiciary is exercising their sentences. And we're very glad that at least we have a magistrate here who is working in a way that it doesn't matter what we talk about liberty rights and freedom rights. We have to look at interests of society as a whole, and she has managed to uphold that.
The matter will be back in court on the 12th of March. Nosipho Mncube, SABC News, Johannesburg.